You're probably watching this video at a time when you've filed for your trademark application a few months ago, and either you're just anticipating receiving that letter from the trademark office because you can't wait for your registration, or maybe you've already opened it and discovered that that office action isn't an allowance, it's actually a set of rejections. What are some of the common rejections, which are what we're going to cover in this video? And then how do you respond to those? Well, we'll give you some hints along the way, but just know that your attorney is there to help you overcome these. They will have seen them before if they're an experienced trademark attorney, and they'll know how to respond and give you an honest evaluation of your chances moving forward. So the most common kind of rejection in a trademark application that's also a challenge to overcome sometimes is called likelihood of confusion. What this means is that the trademark examining attorney in their search found other marks that look like or sound like yours in a category or for a good or service that is close enough to what you're selling that it might cause consumer confusion. Another kind of rejection that's really common is merely descriptive rejections. A merely descriptive rejection is when you've tried to apply for a trademark on a product where the name kind of sounds like the product itself, or maybe incorporates the product of itself. So, for example, tasty hamburgers for a hamburger stand would be rejected for being, say, merely descriptive. The way you overcome that kind of rejection is with examples and evidence of distinctiveness. One example of cutting a merely descriptive rejection off at the pass occurred when I was working for a large law firm. The Texas Rangers wanted to register the name The Ballpark in Arlington. Well, obviously, it's describing a ballpark in Arlington, Texas. And so, in anticipation of a merely descriptive rejection, the attorneys working on the case submitted evidence that this particular name, the ballpark in Arlington, was being used in all kinds of advertising and promotion along with the Texas Rangers for their ballpark. And because this application was submitted with evidence of distinctiveness, the examining attorney allowed the application and the mark went on to register. Another common basis of rejection is that the specimen that's submitted with the application is just improper. So maybe it's a photograph, or maybe it's a website that's submitted without a URL or the date that it was captured, but there's just something not right about the specimen. I've even seen applications with a rejection where the specimen was submitted with the logo photoshopped on an item. That's just not permissible. Another basis of rejection is that a classification is improper, which means that the applicant or their attorney chose one class when another was more appropriate. You might be thinking what I mean by classes. You should see the video on that particular topic, which you can access here. So a trademark class is kind of like the old Yellow Pages, right? You would see a section on automobiles and one on pet supplies. If you pick the wrong category for the thing you're selling, that's a foul. And so the trademark office is going to make you select the right category if you're able to do so. To learn what those limitations are, ask your attorney. Another basis of rejecting a mark is that it's merely ornamental. This is most frequently found when an applicant is trying to Photoshop a logo on an item and kind of pretend like they're selling it. So a merely ornamental rejection is a basis of rejection. Now, there are actually two kinds of rejections that fit in the descriptive trademark category but they're special. One is based on a geographic name. So if you wanted to name your product New York cheese and try to register it, New York would be treated as a generic name by the trademark office. Similarly, surnames. So surnames are also inherently descriptive by definition in the trademark office. McDonald's is a surname. Now, you might be wondering, how do some of these companies get trademarks on surnames like McDonald's or geographic names like Alabama barbecue sauce? And the answer is they've advertised enough and promoted their product and brand so much that they've created a distinctive impression in the consumer's mind. And so they can show distinctiveness. And by showing distinctiveness, you can overcome that merely descriptive presumption in the trademark office. Now, the last basis of rejection that we'll touch on here is in the trademark office called lack of distinctiveness. And that's kind of like likelihood of confusion, but I just want you to be aware that it's a potential basis of rejection. If you see it, it's nothing new. Your trademark attorney should be able to help you understand it and address it. So these are the most common basis of rejections. To learn more about them, pick up a free copy of my book, Trademarks Made Simple, and keep watching these videos.